Right. Good afternoon, ladies and gentlemen. My name is Kgopotjo Lebepe, and I am a candidate legal practitioner at the Unisa Law Clinic at the Polokwane branch. Thank you so much for joining me today for the topic that will be the difference between dying without a will and dying with a will, also known as the intestate estate and the testate estate. The first topic that we'll begin to discuss today is dying with a will, also known as the testate estate. Now, you ask yourself, how will a deceased estate be divided? This, of course, will require a valid will. A valid will determines how your assets will be distributed amongst your heirs upon your death. Without a valid will, your assets will be distributed in terms of the Interstate Succession Act of 1987, where the rules of the devolution may not be in accordance with your actual last wishes. This is why it's important to have a will drafted. Who will be responsible to wind up your estate? An executor will make sure that your property is distributed according to the terms of your will. You ask yourself, what is an executor? An executor of an estate is an individual that will, of course, be appointed to administer the last will and testament of a deceased person. The executor's main duty is to carry out the instructions to manage the affairs and the wishes of the deceased, aligned in accordance with the will. The executor will be in a position to collect and account for your assets at the date of death and settle any outstanding debts that you have incurred through your lifetime. Excuse me, guys, load shedding just hit. As we continue, where no executor is appointed, the master of the high court will appoint someone, usually a family member. It is important to appoint an executor that knows what they are doing, who is trustworthy and honest. The executor ultimately plays an important role in the administration process of winding up the estate. This process will be explained in detail towards the end. Now, if you have left behind minor children, deciding on the guardianship and who will take care of your minor children is very important. A will allows you to stipulate who you would prefer to look after your minor children, should you no longer be around to do so. If there is no will in place and a guardian is not appointed, the state will decide who will be in the position to take care of your children. This might also be in a disadvantage on your side because your children might be taking care of a person that you didn't want to be taken care of to begin with. How do you guide your family in a time of loss? A valid will provides comfort and a peace of mind to your family in the event of your unexpected death. In the will, you would have named the executor to administrate your deceased estate. You have identified your beneficiaries and their bequests under the will. You would have provided for minor beneficiaries by establishing a trust as part of the provisions of your will. You would have appointed guardians and custodians of your minor children and may have inserted additional provisions into your will. This will be dealing with funeral arrangements and special bequests or instructions that you would have outlined in your will. Let's discuss the second topic, dying without a will, also known as the intestate estate. If you die without leaving a valid will, your estate will devolve according to the Interstate Succession Act of 1987. In the case of a marriage in community of property, one half of the estate belongs to the surviving spouse, or surviving spouses. And although it forms part of the joint estate, it will not devolve according to the rules of interstate succession. And that is an important statement to note. How will an interstate estate be distributed to the beneficiaries, right? Because we all are curious to find that out. All deceased estates will be distributed in terms of the Interstate Succession Act. This means that the beneficiaries in order are the ones that are preferred, which, number one, we consider the spouse or spouses of the deceased. Secondly, we will also consider the descendants of the deceased, which are the children in this case. Thirdly, we will consider the parents of the deceased, only if the deceased died without a surviving spouse or descendants, which is the children. Fourthly, we will consider the siblings of the deceased, only if one or both parents are predeceased. The Interstate Succession Act should be read in such a way that it can accommodate cases where the deceased was a husband in a polygamous customary union, which is not unfamiliar to us since we live in a country that does practice that. When the deceased left only the spouses and no descendants, children, the wives will inherit the estate in equal shares. When the deceased left spouses and descendants, the spouses and descendants will inherit the estate in equal shares. But this is important to state and to note. Each wife should at least inherit 250,000 rand. When the estate is not large enough to allow each wife to actually inherit the 250,000, the spouses will inherit the estate in equal shares, while the descendants, the children, will not receive anything. Now, let's touch base on in the events of the interstate succession, what will actually happen. So we're going to take it step by step. What will happen if the deceased is survived by a spouse or spouses, but not by descendants, meaning no children, only wives? The spouse or spouses will be the sole interstate heirs in the specific estate. Who is the spouse for the purpose of the interstate succession? As a starting point, it can be said that any party to a valid marriage in terms of the Marriage Act 25 of 1961, a civil marriage, is regarded as a spouse for the purposes of interstate succession. A party in a subsiding customary marriage, which is recognized in terms of Section 2 of the Recognition of Customary Marriages Act 120 of 1998, is also a spouse for an interstate succession purposes. These marriages include customary marriages which were validly concluded before the Act came into operation and which still existed at the commencement of the Act, as well as marriages that were concluded in terms of the provisions of the Act. After the commencement of the Commission of the Act, Section 3.1 of the Reform of Customary Law and Succession and Regulation of Related Matters Act 11 of 2009, which came into operation on the 20th of September 2010, it has created a further group of women who qualify as spouses for interstate succession purposes. They are the seed-bearing women in terms of customary law. Let's look into persons that are married in terms of Muslim and Hindu religious routes. Should be regarded as spouses for purposes of interstate succession, and they are also entitled to inherit from their deceased partner in terms of the Interstate Succession Act. Despite the fact that their marriages is not recognized as a valid marriage in terms of our current law. Persons who died before the 1st of September 2006 and were partners in a same-sex life partnership at the time of their death should be regarded as spouses for the purposes of the interstate succession. While persons in the same-sex relationships who died on or before the 1st of December 2006 should only be regarded as spouses if they had entered into a marriage or a civil partnership in terms of the civil union. Now let's see what will happen if the deceased is survived by descendants but not by spouses. It means that the children of that estate will inherit the interstate estate. Let's also look into what will happen if the deceased is survived by a spouse or spouses as well as the descendants. The spouse or spouses inherit a greater of 250,000 Rand per spouse or a child share. If the children of the balance of the estate, a child share is determined by dividing the interstate estate by the number of the surviving children of the deceased and the deceased children who have left issues, plus the number of surviving spouses. Now, I'm going to illustrate you by giving you an example. Example of a child share in event of a polygamous marriage. In this case, the value of the interstate estate, let's just say it's 2 million Rand. The deceased is survived by 2 spouses and the 3 children. A child share amount to 400,000 Rand, being 2 million divided by 5. The 3 children and the 2 spouses. The child share is greater than 250,000 Rand. Therefore, each spouse will inherit 400,000 Rand and each child will inherit 4,000 Rand. 2 million less than 800,000 to be by the spouses divided by 3. Now let's look into an example of a child share in the event of a monogamous marriage. In this case, the same calculation will apply as in the previous example. Only the children's share is calculated by dividing the value of the interstate estate by 4, the surviving spouse, and each child will inherit 500,000 Rand, which is 500,000. Let's look into what will happen if the deceased leaves no spouse or descendants, but both parents are alive. His or her parents will inherit the interstate estate in equal shares. So the mother, the father will get an equal share of the deceased joint estate. What will happen if the deceased left no spouse, no descendant, but leaves one parent, while the deceased parent left descendants, which are the brothers and the sisters of the deceased? The surviving parent will inherit half of the interstate estate, and the descendants of the deceased parent will get the other half, meaning your siblings and your brothers will get the half of, for example, your mother, if she's predeceased. What will happen if the deceased leaves no spouse, no descendants, but leaves one surviving parent, while the deceased parent did not leave any other descendants? The surviving parent will inherit the whole estate, meaning you don't have brothers or sisters that will inherit the predeceased mothers. Deceased does not leave a spouse or spouses or parents, but both his parents left descendants. The interstate estate will split into equal parts. One half of the estate is then divided among the descendants, which are your brothers and sisters, related to the deceased through the predeceased mother, and the other half among the descendant relating to the deceased through the predeceased father. I hope that's understanding to you guys. Also, what will happen if the deceased has left no spouse, no descendants, no parents, but only one of the predeceased parents left descendants, which are your siblings, your brothers and your sisters? Your brothers and the sisters of the predeceased parent who left the descendants will inherit the entire interstate estate. What will also happen if the deceased does not leave a spouse, no descendants, no parents, or no siblings or brothers? This comes in where your relative, your nearest blood relatives, will inherit the entire interstate succession. What will happen if the deceased is not survived by any relative? Only in this instant will the proceeds of the estate devolve on the state. Now, a lot of people have asked, what is the position with regards to a child of the deceased born out of wedlock? A child whom is born out of wedlock can inherit from both relations, the same as a child in wedlock. So it doesn't matter whether you had a child in your marriage or outside, that child will inherit. What is the position with regard to an adopted child of the deceased? An adopted child will be deemed to be a descendant of his adoptive parent or parents, and not to be a descendant of his natural parent or parents, except in a case of a natural parent who is also the adoptive parent of that child, or at the time of the adoption, the deceased married the adoptive parent of the child. Ladies and gentlemen, that is the conclusion of my presentation. Please note that questions and answered will be presented by my colleague Keisha on the 16th of August, but you are more than welcome to also respond and write down your questions below on this video, because this video will be posted on our Facebook page. It will also give you an opportunity to ask questions about what I have presented today, which is what happens if you die with a will and without a will. I hope that this was informative. You will also be given an opportunity, a week, where you will ask all the questions on each and every single presentation that my colleagues and I have made. Last week, Mr. Mahlangu has presented. This week, I have presented. And the next week, Mr. Sfiso Mahlangu will be explaining what you need for a will to be valid, because it is important for a will to be valid. Thank you so much for giving me the opportunity and the grace, and for each and every single person that has tuned in. I hope that this week's information session was as helpful and educative, and I also hope that what you have learned from today, you will also encourage your parents to write and draft wills, your aunts, your uncles, because it is important. Usually, if you want your estate to be, concluded quicker, a will also assist in that regard. Thank you so much once more for tuning in for this week's information session, and I hope that you found it as informative and educational as I did. Have a lovely day, and don't forget to ask all the questions that you might need on this video. If you need to go back to this video, it will be posted on our Facebook page, just so that you go back to all the information that you might have missed. Have a lovely day, ladies and gentlemen, and see you next week for what you need for a will to be valid that will be presented by my colleague, Mr. Sfiso Mahlangu.